Hey guys, so I'm gonna be going over the judicial branch notes today. Um, if you have any questions as we go throughout these that pop up, feel free to just message me, shoot me a Schoology message, and I can get back to you. But otherwise, we'll get started here. Okay, so really quickly before we talk about some of those intro questions, um, with the latest update from AP, they're saying that the online AP exam could be a 45-minute FRQ exam only. Now, this is all speculation. We won't know more until April 3rd. But if we look at the required um, different styles of FRQ and how long College Board suggests for each of them, most AP teachers are thinking that we're going to have a concept application FRQ, as well as a SCOTUS comparison FRQ, which we have not covered yet. We will be covering that in the coming weeks and doing some practice with that because that's kind of the expectation. But from a content perspective, for the SCOTUS FRQ, knowing the required SCOTUS cases, super important. Um, so I did put together a class Quizlet. That link is in the exam review folder on Schoology. There is within the class this Quizlet that has just all of the required SCOTUS cases. So like the constitutional clauses involved, what was the significance, those sorts of things. So feel free to take a look at that, use that as a study tool. We'll be talking more about SCOTUS cases in the coming weeks, and we'll be doing a little activity with them as well. So learning targets for chapter 16, we're going to talk a little bit about judicial review, look at the development of the federal courts, discuss basic things like structure and jurisdiction, different types of jurisdiction, and kind of how the federal courts operate. And then we'll talk briefly about some checks on judicial power. So, a couple of these are pretty open-ended. Okay, the first one asks why federal judges should serve for life. Maybe you don't think they should, that's totally legit. So you can go ahead and answer your thoughts on that in the box. For your guys' homework after this lecture, you're going to be looking at excerpts of Fed 78, where Hamilton talks about the structure of the federal courts and whether or not judges should serve for life, what his thoughts on that were. So that'll give you a little bit more context. But remember, within Article 3 of the Constitution, judges serve for a term of good behavior. So essentially, this means that they are in that position until they retire, resign, or potentially die in office. One of the major reasons for this is that, and Hamilton will expand a little bit more on this, but one of the major reasons is that they really wanted the judiciary to be a non-political body. They wanted it to operate independently of the other two branches, and to do that, they needed to make sure that judges couldn't be taken over by the politics of the day. And their solution to that is you get to serve for life. And maybe you think that's a good idea, maybe not. But if it's evidenced at all in recent Supreme Court appointments, the appointment process itself can be very political in nature. Now, federal courts are able to declare laws unconstitutional. That's what we call judicial review. Judicial review you will not find anywhere in the Constitution, but it is a precedent that's set up by the early courts, but they didn't dream this out of thin air. Again, it's talked about in Fed 78. So it is technically an acquired power, not a constitutional power. We've talked about briefly in, I think, the first unit about Marbury versus Madison. We did that case brief. And in Marbury versus Madison, they create that precedent that the courts have to be able to do this, otherwise the Constitution could become meaningless, right? Because what if Congress and the president are able to do things that the Constitution technically does not give them power to do? It's a little ironic because you won't find judicial review in the Constitution either. But when we look at our upper courts today, like the Supreme Court in particular, or even our Court of Appeals, that's largely what they're doing. That's their caseload. Looking at decisions of Congress, right? Actions of Congress, actions of the executive, looking at, previous laws as they're applied to certain scenarios, different cases, so on and so forth. And then, should federal judges only interpret existing laws, or should they be able to create new laws? Now, just based on that phrase, most people would probably say they're just interpreting existing law, right? They're not the legislative, they shouldn't be able to make law. But many times their decisions, how they interpret law, does have an impact on that law, right? Like, for example, we are going to talk a little bit about criminal rights. One of the major criminal rights cases is Miranda versus Arizona. Now, in Miranda versus Arizona, they interpret some of the criminal rights found within the Bill of Rights amendments, right? Like your right to remain silent, found within the Fifth Amendment. And the way in which they interpret that law is they set this precedent that if criminals aren't made aware of their rights, we're going to throw out any evidence that you collect, so it cannot be used in the court case, right? Now, they didn't actually change the law on the books, but by setting that precedent, they send a message to police stations nationwide and law enforcement that you do need to read people their rights, which we now call the Miranda rights. Otherwise, nothing you gather will be used in the court of law. So that procedural change is pretty huge, right? They didn't technically make a new law, but they did make some changes, right? We'll talk a little bit about judges' views on this particular question. This comes down to an idea called judicial philosophy, which is very much so like a personal ideology. And we'll talk a little bit more about that. All right, so some basics here. The US Constitution, I've mentioned it before. Article 1, we have Congress. It's lengthy, it's detailed. Article 2, we have the executive branch. A little bit more concise, right? And by Article 3, it seems as though they're tired. Article 3 is really short, but it does do a few important things. 1, sets up the Supreme Court. That's the only court that's set up under Article 3 of the US Constitution. But they do create a procedure for making lower courts because they know the Supreme Court isn't going to be able to handle the whole caseload of the nation. So they say Congress can create the lower courts. They can create the structure. We'll talk a little bit about what that structure looks like. Article 3 does not lay out any requirements for judges, right? Thinking back to Article 1 and Article 2, you have like age requirements, residency requirements, so on and so forth. That doesn't exist within Article 3. Now, the idea behind it was that you could find the best person for the job, right? I usually always have a student or two ask like, so technically a 6-year-old could be a Supreme Court justice? Yes, but remember, Supreme Court justices have to go through that congressional approval, so it never happened. But the idea was that we would find the best person for the job because this is a really, really important job. You're in charge of upholding the laws of the nation, right? So this isn't a job that they were going to take lightly. Now, there are some informal requirements, right? There aren't technically any requirements in the Constitution, but there's some expectations that we have and that the US Senate has in selecting or appointing federal judges. So those things may be like a background in law, some education, right? At least a college degree or a law degree or a doctorate or whatever it may be. By the time we get to the Supreme Court, we're expecting some judicial experience, right? So maybe you were a district court judge or worked on a court of appeals, that sort of thing. And then age is a factor too, and age is something that actually gets brought up relatively frequently when people are talking about Supreme Court appointments because they are lifetime appointments. Sometimes the opposition is really petrified to put like a 40-year-old into office because they know that person could sit there for the next 50 years, right? That's a long time to have someone serving on a court. So it's something that is considered definitely as well. And like I mentioned, federal judges serve for that term of good behavior, which means life, retirement, or resignation. All right. The judiciary today, we have had a decline in federal appeals court nominee confirmations. I'll show you guys a chart on the next slide here, I think. Confirmations of judges, both at the district court level, the Court of Appeals, and certainly the Supreme Court, have become more politicized. And so there have been judges that have been turned away because the majority in Congress doesn't side with them, right? Doesn't side with the president in their who they think should fill in that position. We have lengthier confirmation hearings as well today, oftentimes taking between 140 to 180 days from the time of appointment by the president to confirmation by the Senate. So super lengthy process. Today, federal judges are making more policy decisions, and that is likely why this process has become politicized, because most of our differences in politics revolve around differences in policy. And so that has an effect on the nomination process. Federal judges are more ideological. People are more uncertain of whether or not they can fulfill that role and truly be impartial, right? The Senate is skeptical, in other words. All right, so here I have the confirmation rates. So you can see number of nominations in green, and then the number of people confirmed in orange or yellow there. So you can see, with the exception of like W. Bush, we kind of have a downward trend when it comes to the number of people that are actually confirmed. And then you can see a huge difference between the presidencies of Bill Clinton and George W. Bush as compared to Barack Obama and the length of time that it took to actually get from appointment to approval. All right, so brief recap of Marbury versus Madison here. We talked about this in Unit 1. I would totally expect it to show up on the AP exam. So I'm not going to give you all of the information about it, but if you need a refresher, go back, take a look. So remember with Marbury versus Madison, this is a political scuffle, right? So in the last days of his presidency, Adams nominated all these people to fill these appointments within the bureaucracy, essentially. They call them the midnight appointments, right? Um, and so at the time, under Adams, John Marshall is the Secretary of State. It is his job to essentially extend the offering, okay? Um, like provide the job offer letter. And so Marbury is one of these people that is appointed in the last days of Adams' presidency. Now, Jefferson then comes into the Oval Office and he's of a different party, right? Jefferson is a Democratic Republican. Adams was a Federalist. And so Jefferson comes into office and he orders his now Secretary of State, Madison, not to deliver the commissions. Those are those job offer letters. And so Marbury, one of the guys appointed by Adams, is really upset about the fact that, hey, he was supposed to get this job and he's not getting it now because Madison, the new Secretary of State, won't deliver the commissions. So Marbury sues Madison. Now, the politics of this is far less important than the precedent that it sets for the judicial branch. So what they did is they were looking at the Judiciary Act, which was a law passed by Congress, setting up some of the like structure and rules and procedures of the judicial branch, right? Because Article 3 gives them that power. Now, the Judiciary Act would have allowed the Supreme Court to essentially order the president to do something. So the Supreme Court, under the Judiciary Act, could have ordered Madison to hand over the commission to Marbury. Now, John Marshall has become the Chief Justice of the Supreme Court. Nowadays, if you were the one that failed to deliver the commissions, and now you are the Chief Justice of the Supreme Court, there would be public outcry because you should excuse yourself for this conflict of interest, right? But Marshall still sits on the court. Marshall is a huge Federalist, and through his time on the court, he only expands the power of the federal government. Now, Marshall looks at the Judiciary Act of 1789, recognizes that it says he does have the power to give Marbury his commission, but the decision that he makes in that case is actually that the Judiciary Act of 1789 is unconstitutional. He said the judicial branch should not be able to tell the executive what to do, right? That like destroys checks and balances. So, in making this decision, he sets up this precedent of the Supreme Court being able to determine whether or not an act of Congress or an act of the president, like an executive order, is constitutional or not. And then from here on out, pretty much, that's the job of the Supreme Court, to determine whether or not laws are constitutional or not. Judicial review, as a result of this case, becomes the chief weapon for the judicial branch in the system of checks and balances, right? It is pretty much the only check that the judiciary has on Congress and the executive. So it's an important one, right? And John Marshall doesn't just do this, like I said, he's thinking back to Fed 78, which you'll look at, and what Hamilton had suggested in this regard. All right, so I think we've gone through most of this here. We'll talk a little bit about original jurisdiction later on in the notes here, so I'll let you know what that looks like. Okay, so at the bottom here it says, how can the courts be checked so that they don't get too powerful or they don't get too dangerous? Few different checks on the judiciary. With the exception of the Supreme Court, or SCOTUS, higher courts can check in on lower courts, right? So the structure, we'll look at this in a minute, but the structure of the court system is you have U.S. district courts, Court of Appeals, Supreme Court. And so if the district court makes a decision, someone can appeal to the Court of Appeals, and the Court of Appeals, as the higher court in that scenario, can tell the district court that they were wrong. Second, judges are appointed by the president and confirmed by Congress, right? So that's an executive and legislative check on the judiciary. Federal judges can be impeached. It's few and far between, but they are a public official, just like the president, just like our congressmen and women, right? They can be impeached. Congress, because Article 3 gives them the power, can pass laws that alter the powers of the federal judiciary, right? Because they're the ones that set it up in the first place. So if they wanted to limit jurisdiction or, you know, reduce the power of the judiciary in some way, they could likely do that. And then the other thing is, federal judges really can't have a personal agenda, because the only thing that they can make decisions on are things that are brought to them, right? So they may have a very particular personal ideology about, like, women's right to choose, right? Pro-life versus pro-choice, the whole abortion issue. They may have a personal agenda when it comes to that issue, but unless someone brings a court case up that involves that issue is untouchable, right? So we have to have some litigation that comes to them. They can't, like, really pick and choose what issues they're going to address. All right, so judicial philosophy here. There are different judicial philosophies. People oftentimes use the terms liberal and conservative to talk about judges. They'll also use those terms to talk about congresspeople or presidents. When we use those terms to talk about judges, it has a different connotation. I'll talk about that in 1 second. Okay, so judicial activism, a judge who practices judicial activism, we often call liberal. Okay, someone who practices judicial activism views the Constitution as a living document that needs to change with the times. Okay, these judges often make bolder policy decisions, sometimes even charting on new constitutional ground with a particular decision. And so that can be controversial, right? Because some people see that as legislating from the bench. I gave you the example of Miranda versus Arizona. That is passed by the Warren Court, which is probably the most activist court in US history. And if you don't know much about the Warren Court, I really encourage you to take a look at that, because they made some really, really important decisions in regards to personal rights and freedoms and rights of the accused and all of those things. Someone who practices judicial activism thinks that the courts should use their power of judicial review to correct the pressing needs that maybe otherwise the political process leaves alone. Think Gay marriage. Gay marriage becomes an incredibly important issue in the 2010s, early 2010s. Congress isn't interested in touching it. Congress has a law at the time that was passed in the 90s called the Defense of Marriage Act. Federally, gay marriage is illegal under the Defense of Marriage Act. In Congress, even though there's this whole social movement going on, Congress isn't interested in looking at that issue. It's court cases that find their way to the Supreme Court that eventually have the Supreme Court look at DOMA and its constitutionality, and they are the ones that make the decision that makes gay marriage legal nationwide, right? Because they find DOMA unconstitutional. And so that's a very activist decision in that regard. Now, judicial restraint. Judicial restraint, people who practice this think that we should think of the Constitution as the way that it was viewed by the founders. Sometimes we call this original intent, right? Someone who practices restraint thinks that we should take it word for word what's on the page. That's how we know what the founders intended. We shouldn't be reading between the lines. Someone who practices judicial restraint believes that judges need to stick closely to precedent. Precedent are those previous decisions that they have made, that previous courts have made, and they should play a minimal role in policy. Now, oftentimes judges who practice judicial restraint are called conservative judges. However, where this differs from being a conservative politically is, take for example Roe versus Wade, where abortion is made legal nationwide, and that is a Supreme Court precedent, right? The Supreme Court often treats their own precedent as standing law, because if you're switching your decision on these things all the time, what's the value in your decision in the first place, right? So someone who truly practices judicial restraint would stick by precedent, would stick by previous decisions. So someone who's conservative politically would probably be opposed to Roe versus Wade. But someone who is a conservative judge, if they're truly practicing judicial restraint, would likely stick to the precedent or the decision made in Roe versus Wade. So we have a conflict of policy ideas between a conservative judge and someone who's conservative politically, and a liberal judge and someone who's liberal politically, right? It's not a perfect overlap. Okay, so on your sheet it asks true or false. Judicial activism equals liberal. That is false in a political context, right? Even though it's oftentimes how we refer to judges. I would encourage you, this is an option in your Civil Rights and Civil Liberties hyperdoc. I would encourage you to watch the episode of The West Wing. It's called The Supremes, because that's all about judicial activism versus judicial restraint, really, in the role that that plays in a appointment to the Supreme Court. All right, so again, you kind of have that diagram there. We don't have a perfect overlap. Now, the founders' view of the judiciary. They do not expect the federal judiciary to play a significant role in public policy. Really, they viewed their role as one that was supposed to apply existing law to make sure that laws were being followed, right? Because a judiciary doesn't exist under the Articles of Confederation. Hamilton in Fed 78 calls the judicial branch the least dangerous branch of government, He doesn't think it has the power to become too powerful, essentially. Now we have an evolution of the judiciary, right? So, under the Articles of Confederation, like I mentioned, there's no national courts, no national judiciary, and the states were essentially responsible for applying and interpreting existing law as they saw fit. Pause. I'm grabbing my dog. Winnie, come here. She wants to say hi. Say hi, Winnie. Okay. Okay. She's not gonna like it when I have to go back to work. She's been hanging out with me all the time. All right, so the problem with states interpreting law is that there's disputes between states in how they interpret law. There was also no extradition. So if you broke a law in Virginia, just go to New York. They probably don't enforce that law there. Okay. So that became problematic as well. Oftentimes the decisions of courts in one state were ignored by other states completely. Now, the early Supreme Court under John Marshall, he is not technically the first Chief Justice, but he is really the first Chief Justice that matters. Okay, he greatly expands the power of the Supreme Court, okay, and of the national government. He does this in Marbury versus Madison first. He also decides cases like McCulloch versus Maryland, which, if you remember, when we talked federalism in Unit 1, that's where Maryland tried to tax the national bank. And again, John Marshall and the Supreme Court favor the national government and the use of implied powers. All right, some important courts. Judges and courts change over time. So I have a timeline for you. You can recreate. In terms of the modern courts, one of the most important, as I mentioned, is the Warren Court. Earl Warren was appointed by Eisenhower. Eisenhower thought that Earl Warren was going to be a moderate judge, that he was going to bring balance to the court. The thing is, when you serve a life term, you can say whatever you want to get appointed. And then once you're in that position, your whole judicial philosophy may change. So Earl Warren becomes a very activist judge in a way that Eisenhower never expected. He referred from there on out to Earl Warren as the biggest damn fool mistake he'd ever made. So he didn't really like that decision. The Warren Court greatly expands rights of privacy, rights of the accused, so on and so forth. Now the Burger Court, a court's always named for their Supreme Court justice, Chief Justice. So the Burger Court, we still had a lot of associate justices that served under Earl Warren. So the Burger Court is a purple court of sorts. It's a balanced court, right? And they are in there from 1969 to 1986. Now, as time goes on and more judicial appointments are filled, lots of people had a lot of issues with the decisions of the Warren Court in particular, but also the Burger Court, right? Roe versus Wade is decided by the Burger Court. And then we have this whole like conservative revolution of sorts, right? And that leads to the appointment of William Rehnquist. Rehnquist is a very conservative judge, and during his time on the court, they continue to appoint conservative judges. So this is a conservative court. Now, the interesting thing about Rehnquist is Rehnquist was deeply, personally opposed to the decision that the Warren Court made in Miranda versus Arizona. He hated it. But two different times, similar cases come before the Rehnquist court, and he is such a restraintist and original intentionalist that he sticks by precedent. So even though personally he hates the decision in Miranda versus Arizona, when he has the chance to overturn that decision two separate times, he doesn't do it. Okay. Now the Roberts Court is what we have today. John Roberts is our Chief Justice. The John Roberts Court today is a more conservative court. It has had periods where it has been imbalanced. So Kennedy, before he resigned from the court, he was really the swing vote. There were like 4 pretty staunch conservatives, 4 pretty staunch liberals, and Kennedy would often swing the vote on the Roberts Court. As President Trump has gotten Supreme Court appointments, he's had 2 now, that court has become more conservative. Other things on your sheet, it says FDR and the New Deal. You guys may have learned a little bit about court packing in APUSH. FDR's New Deal policies are originally overturned by the courts, found unconstitutional, seen as like violation of the 10th Amendment and things like that. And then there's court packing, right? And more liberal justices join the court, and then all of a sudden, New Deal legislation is a-okay, right? Sometimes a court will make a really big decision, like they did in Roe versus Wade in 1973. And then as time goes on, they'll set more limitations to that decision. So originally with Roe versus Wade, in the first and second trimester, abortion is pretty much allowed, no questions asked. As time goes on, they become more restrictive. So, maybe only allowing true freedom and decision making in like the first trimester, the first 12 weeks of pregnancy. Same sort of thing happened with affirmative action, right? Affirmative action is passed after the civil rights movement, basically to allow for more opportunity for African Americans and minorities in education, in the workforce, and so on and so forth. They have peeled back some of those things as well. Talked about Rehnquist. In his first 5 years on the court, he was an associate justice for the Burger Court. He wrote 24 solo dissents. He kept a Lone Ranger doll because people called him a Lone Ranger. But in 1973, he's one of only 2 justices to vote against Roe in Roe versus Wade. By 1986, though, he's chief, and he has even more Republican appointees that join him on the court. It morphs it to a conservative court, but like I said, Rehnquist doesn't dissent as often after taking that role as chief. All right, so before I talk about this diagram, since about like the early 90s, there have been more movements to restore state rights. So the expansion of the federal government has been reined in a little bit. There is a case in your sheet on it's called the National Federation of Independent Business. It was the Affordable Care Act case that asked whether or not the Affordable Care Act was constitutional. the way they passed the Affordable Care Act was by saying that the requirement to buy health insurance falls within Congress's power to tax, but there were specific mandates. And so the question in this case was whether or not Congress violated states' rights or enumerated powers when they mandated that states essentially follow suit or they could lose their Medicare funding. In this case, they do uphold most of the Affordable Care Act, but they do give states a little bit more power than what's originally allowed in the Affordable Care Act. They say it's not okay that Congress threatened to pull back Medicare funding if you don't comply, that sort of thing. All right, so some types of federal courts. First, we have the constitutional courts. Together with the Supreme Court, they include the Court of Appeals, the district courts, as well as the Court of International Trade. The constitutional courts are also sometimes referred to as just the regular courts or the Article 3 courts. Now, the special courts have been set up by Congress to help hear cases arising out of their expressed powers of Congress. These courts hear a much narrower range of cases, and they're sometimes called the legislative courts or the Article 1 courts. So for example, the U.S. tax court, if you feel that the U.S. tax code is in violation of your rights in any way, you can file a civil suit with the U.S. tax court. The U.S. tax court does not hear cases of tax fraud or not paying your taxes because those are criminal offenses. So they would go to the constitutional courts. All right, you can see our federal court circuits and districts here. We are in the 8th Circuit. There are, let's see here, I guess I have that on the next slide, so I'm going to come back to that. The U.S. district courts are the federal trial courts. They hear over 350,000 cases per year, which is about 80% of the federal caseload. The other 20% is heard in the Supreme Court or the Court of International Trade. Now, jurisdiction is basically your ability to hear and decide a case. So district courts have original jurisdiction. That means they're the first to hear the case in more than 80% of cases within the federal court system. Please stop biting me. District courts hear both criminal and civil cases. I am trying to reschedule our field trip for the end of May. I'm hoping that it can happen, but that is at the district court. And I talked a little bit to the judge about what sort of cases they hear, and she does hear both criminal and civil. So hopefully we get an opportunity to talk to her a little bit more about that. So most decisions of the district court are final, not appealed to a higher court. There are, of course, people that will appeal their cases, but for the most part, what the district court decides is what goes. Now for the appellate courts, we have 12 judicial circuits. So like I said, we're in Judicial Circuit 8. Each one of those has a court of appeals. So you can see on this chart here that ours is in St. Louis. And then you have the Court of Appeals for the Federal Circuit, which is located in Washington, D.C. So 13 total appellate courts. Each of them have anywhere from 6 to 28 judges that serve. And each of those judges is overseen by a Supreme Court judge. So we have 179 appeals judges in all. Most of the time, a court of appeals is going to have anywhere between 3, usually it's 3, sometimes it's 5 judges sit on a particular case. So Um, there's not jurors, right? They're just like reviewing the facts of the case. So these Court of Appeals only have appellate jurisdiction. That means they don't get to hear the case for the first time. It's already been heard before. Like I said, they do not conduct trials. There's no jury. There's no new evidence admitted. It's just the judges reviewing the facts of the lower court. Less than 1% of their decisions are appealed to the Supreme Court. So for most cases, this is the end of the road. The reason they're there is to guarantee the right to a speedy trial, right? Now, in reality, it's not that speedy of a process regardless, but it would be a lot slower to get your court up to the Supreme Court than if we didn't have the Court of Appeals. All right, so selecting judges, the president nominates, the Senate has to confirm. There's a number of people involved in this process, right? You have the president's closest legal and political aides. Usually the attorney general takes the lead in putting together a short list of people that they should consider. You also have influential senators, right? People like Mitch McConnell, or people who sit on the Senate Judiciary Committee, or minority leaders like Chuck Schumer, right? Those sorts of people become very important. Members of the Judiciary Committee, interest groups. What? Interest groups are really important because they know in many cases that there's likely to be a case that affects their interest that comes before the court. So they like to be really involved in that. This video, I wonder if I can play it here. No, it's not gonna work. This video is kind of funny. This is from when Elena Kagan got appointed to the Supreme Court, and they asked her about her religion. She's Jewish. One of the senators asked her what she does on Christmas, and she says, well, like any good Jewish person, I go and eat at the Chinese restaurant. So they thought that was kind of funny. Sometimes there is a litmus test, which is basically a tough question about whether or not we should really proceed with nominating an official or appointing them. Would this person pass the Senate approval process, that sort of thing. And so lots of times the litmus test question is a question about some really controversial issue that they know is going to be divisive. Lots of times today, litmus test questions revolve around how the judges view the decision in Roe versus Wade. If you watch the West Wing episode, they ask one of the appointed judges about her history, and she said that she had an abortion, and they were like, oh no, I don't know if we can proceed with appointing her. All right, you guys have this, oh, not this. You can take a look at this if you want. This is just female judicial appointments and minority judicial appointments, and then this is in your chart. So you can take a look at this. This is just kind of how the flow of the federal courts works. On the next slide here, we have types of jurisdiction. All right, so most of the cases that are heard in the federal courts fall within their exclusive jurisdiction. This means that these cases can only be tried in federal court. Winnie, what are you doing? So some examples would be like a case involving an ambassador or some foreign representative, a trial of a person that was tried with a federal crime, a suit involving infringement of copyright, right? All of those things. Concurrent jurisdiction is when the power to hear cases shared by both the federal and state courts. One example is like if you were suing someone from Minnesota, so a person of a different state, and the monetary amount involved was over $75,000, you could opt to have that case heard at either the state or federal court. All right. A court in which a case is first heard has original jurisdiction, as we've already mentioned, and then a court that hears a case on appeal has appellate jurisdiction. So pretty straightforward there. Now, this graph shows the Supreme Court caseload for 2001 to 2011. They show about 9,000 cases on the docket each year, but most years the Supreme Court isn't going to take any more than like 100 for full review. So you can see that like full review is the blue that argued during the term. You also have those that are reviewed or decided without an oral argument. The major reason they can't take more than 100 cases is that there's lack of time, right? They don't have enough time in their year to take much more than that. So what they're going to do is they're going to look at the decisions of the lower courts, and a lot of the appeals they're just going to throw out. They're going to dismiss them because they agree with the lower court decision. They are more so looking for cases that have significant legal impact. They're not interested in making a decision that would literally only affect one individual. We're looking at significant legal impact, right? Something that's going to affect thousands, if not hundreds of thousands of people, maybe millions, right? All right. So, for jurisdiction of the Supreme Court, they have both original and appellate jurisdiction. However, most cases come to them on appeal. They usually come from either the highest state court. So in most states, that's going to be like the North Dakota Supreme Court. And the Federal Court of Appeals. They rarely come straight from the district courts, so on and so forth. So the Supreme Court can issue a writ, and basically this is when they can order a lower court to send up the records of a case for review because they believe it's worth looking at. And so this is how most cases do find their way to the Supreme Court. Gideon versus Wainwright we'll talk more about when we get into some Supreme Court cases, but this is one of my favorite because Gideon, when he was in prison, he was accused of like breaking into a pool hall. And he defended himself in court. And so from prison, he starts looking at law books, and he wrote a handwritten appeal to the Supreme Court, asking that his conviction be set aside because he wasn't given an attorney. And the Supreme Court issues a writ, and Gideon versus Wainwright becomes a really important case in regards to your rights to a lawyer. And again, this is a court case that's decided by the Warren Court. The Supreme Court can also certify answers to specific questions. So if a federal judge, a lower court, has a question, they just want to clarify, like, what's the procedure, what's the rule of law in this case, and how should it be applied? The Supreme Court is there to answer those questions as well. All right, we're just about wrapped up here, guys. Last couple things. How a hearing works at the Supreme Court is first, both lawyers need to send up briefs. So these are detailed written statements built on facts and precedents of the case. So they file those for the Supreme Court justices to review. If they decide to continue on with oral arguments, then each side gets 30 minutes. And this is not 30 minutes to argue the whole case again. The case has been argued. The justices have reviewed the case. So this is 30 minutes essentially for the judges to ask the lawyers questions and get further clarification. So that oral argument piece is probably the most public proceeding of the Supreme Court. You can sit in on arguments, and they are recorded. However, the actual decision making of the Supreme Court is done in conference. So this is a closed meeting with just the justices, right? The 9 of them, and they discuss cases and they make decisions. And the only way that we know what in the world they decided is they write about it. So they publish, depending on the decision, they can publish 3, 4 different opinions. The one that's important and that becomes like precedent for future courts is the majority opinion. That's the opinion of the court. They cite all the reasons that underpin the decision that they made. And the majority opinion is to be followed by all lower courts. So we can't have discrepancies between judicial circuits. They need to follow the Supreme Court precedent. Then we have concurring opinions. So if someone maybe sided with the majority, but maybe for a different reason, they can write a concurring opinion where they emphasize the majority opinion and provide their reasoning for voting with the majority. And then you have dissenting opinions. So these are written by the justices that do not agree with the decision. Ruth Bader Ginsburg is known for wearing a like blinged out jeweled collar on the days that she publishes a dissent. So I don't know, kind of her funny tradition. But dissenting opinions will often be looked back on when similar cases come up in the future. And then to announce the decision, like I said, they publish those written opinions. Unanimous opinions are usually written by the Chief Justice as well. And then those are published online for everyone to access. Okay. So the importance of precedent, I'm going to have you read a little bit more about in your Chapter 16 handout. You have a quick reading about the importance of precedent and stare decisis. Stare decisis is to stand by things decided. So it's essentially to abide by precedent or to adhere to precedent. So again, someone who practices judicial restraint is going to pay particularly close attention to precedent and oftentimes practices stare decisis. Now, one thing, I think we have a couple court cases that we're going to look at that involve redistricting, gerrymandering. The court is not allowed to hear cases involving political questions. So there have been plenty of gerrymandering cases that have been thrown out because the cases are political in nature. To be heard by the courts, a case needs to be legal in nature and have legal questions. Now there's some debate about whether or not this is how it should be, right? Or whether or not the Supreme Court should be allowed to step in and say, hey, no, gerrymandering isn't okay. And they have in some scenarios, but they only have in scenarios where gerrymandering has occurred based on like race, because then they can point to things like the Civil Rights Act, not when gerrymandering is based on party. So that's something that the Supreme Court continues to kind of look at. All right, that's all I got for you. Just under 1 hour. Let me know if you have questions. And if you haven't yet, shoot me a message and let me know what you're up to. Like, what are you watching on Netflix or Disney Plus or whatever? All right. Talk to you guys later.